All right, to start our second class on the 11th Amendment, we're going to move into the next subsection, which is congressional abrogation. Although the book calls it waiver of sovereign immunity, I think it's important to distinguish between the waiver that occurs when a state consents to suit, and then the waiver that is done by Congress without the state's consent. So, two cases today, Fitzpatrick versus Bitzer and Seminole Tribe. Seminole Tribe being the longer excerpt here and more significant in terms of the impact that it has on the law in general. So let's look at Fitzpatrick versus Bitzer. So we have here the Civil Rights Act of 1964 that is prohibiting employment discrimination. Now, we've looked in the past at various parts of the Civil Rights Act of 1964, so this next point shouldn't be a surprise. Congress used both its Commerce Clause power and its 14th Amendment Section 5 power to justify the Civil Rights Act of 1964. And remember, we looked at, I think they were only note cases, but certainly I discussed the Civil Rights Act cases under the Commerce Clause. So these would be Katzenbach versus McClung and the Heart of Atlanta motel case. And remember, there the court upheld those particular titles which dealt with prohibiting discrimination in places of public accommodation. So remember, those were dealt with a hotel and a restaurant. And the court said those easily pass the Commerce Clause test of regulating things that have a substantial effect on commerce, even if the things regulated look like they're purely intrastate, taking place entirely within the state. And that is because Congress can say, well, if in the aggregate everyone in a small local community engaged in racial discrimination in food service or hotel service, then this could have a big interstate impact on the markets, on the commerce in those types of businesses. And therefore, in those cases, the court said it didn't have to consider whether this was a valid Section 5 14th Amendment piece of legislation because it was so clearly a valid Commerce Clause regulation. But Congress did say that it was using both powers to adopt the Commerce Clause. And again, just to remind you, next week we'll be looking at the Section 5 powers of Congress under the 14th Amendment. So the particular title of the Civil Rights Act that we're dealing with here is the Title 7 that prohibits employment discrimination, prohibits racial and sex discrimination in employment. As originally passed, it only applied to the states as employers, and we've also seen this feature come up before in various pieces of federal legislation, that initially Congress only applies some of these acts to private employers, but then they later on go on to amend them to apply to state and local governments as employers. And that's what happened here. So the statute very directly and very clearly authorizes suits for back pay by employees. So if employees have been discriminated against, and as a result of that discrimination, they've lost money, if they were fired based on a prohibited reason, then the statute says that the fired employee who's been discriminated against can sue the employer, even if the employer in this case is a state or local government. So the question is, does Edelman, the case that we looked at the last class, prohibit this suit for retroactive benefits? Remember, Edelman versus Jordan said that the 11th Amendment prohibited a suit by a welfare recipient in the state of Illinois for back pay, essentially, for the state was slow at processing applications, and the court said it's perfectly fine to issue the injunction telling the state officials you must comply with the law going forward, but it violated the 11th Amendment to award damages that would come out of the state's coffers for that illegal conduct that occurred in the past. So here, this looks like an award for illegal conduct that occurred in the past, and so therefore, isn't this suit prohibited by the rule of Edelman? And you can see over on page 448, the lower courts thought just that. The district court applied Edelman versus Jordan and said that because this is a suit for money damages that's coming out of the state's treasury, Edelman must prohibit this sort of suit. But the court gives us a new rule in this case. The court says that when Congress acts pursuant to the Civil War amendments, those are the 13th, 14th, and 15th Amendments, it can subject state governments to retroactive damage suits, notwithstanding the 11th Amendment. All right? So an important exception to the basic rules that we looked at yesterday, and this is why it's going to be important to distinguish the basis for congressional legislation. And if Congress says, like it does with the 1964 Civil Rights Act, that it's passed on two different bases, two different congressional powers, then it would be incumbent upon you in an analysis to see if the statute indeed can be justified under both of those congressional powers. Maybe it can be justified under only one of the two powers. And if we're talking about 11th Amendment issues, you can see how that determination would impact the outcome here. So why create this exception to the 11th Amendment? So page 448, court says in part 2 of the opinion, second paragraph under part 2, we concluded that none of the statutes relied on in Edelman contained any authorization. So the statutes in Edelman, the welfare statutes, didn't say anything about welfare recipients suing the states. In this case, it's quite different. The legislation clearly says that the people who are discriminated under the statute can sue the state. So bottom of page 448, top of page 449, we see excerpts from the 14th Amendment, and we'll be looking at these in more detail next week. The 14th Amendment, Section 1, sets out the substantive provisions of the 14th Amendment. And the 14th Amendment is essentially a limitation on the states. Remember, this is a post-Civil War amendment. So the southern states are, the Congress, the nation, is thinking of all of the bad things that the southern states did. How can we write constitutional amendments that make clear that those things they did are unconstitutional going forward? So Section 1 says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Right? So those three main provisions of the 14th Amendment, known as the Privileges and Immunities Clause, the Due Process Clause, and the Equal Protection Clause, those will form probably half of your study in Con Law 2, where you look at the substance of those provisions, right? Due process, that's what gives us the constitutional right to all sorts of liberties, sexual liberties, reproductive liberties, abortion rights, marriage rights, equal protection. That's what prohibits sex discrimination and race discrimination. So you'll learn about the substance of that first section in Con Law 2. But go over to Section 5. Congress shall have the power to enforce by appropriate legislation the provisions of this article. So the cases that we look at next week, this case here, will assume that Congress, will assume that the thing that Congress is trying to enforce is indeed fairly described as a Section 1 violation. So the question is, so what exactly does it mean that Congress has the power to enforce by appropriate legislation the provisions of this article? And that's the task that we'll take up next week. But just here, note that separate power that Congress is given. Remember all of our pre-Civil War amendments, congressional powers were contained in Article 1, Section 8, where we found the Commerce Clause. This is, as I mentioned in the last lecture, these three amendments, 13th, 14th, and 15th, are the first times since the original Constitution that Congress is explicitly given more powers. So with that in mind, let's look at the next sentence, the next paragraph there, the last paragraph of the opinion. We think that the 11th Amendment and the principle of state sovereignty which it embodies are necessarily limited by the enforcement provisions of Section 5 of the 14th Amendment. when Congress acts pursuant to Section 5, the court says it is exercising that authority under one section of a constitutional amendment whose other sections, by their own terms, embody limitations on state authority. So, what Justice Rehnquist says in this opinion is he says the Civil War amendments themselves altered the federal-state balance. They represent a shift in the federal-state balance. So if the idea behind the 11th Amendment, and again, this is a big if, and I'll mention at the end various theories to interpreting the 11th Amendment, but if the 11th Amendment represents this general theme of state sovereignty, then what Justice Rehnquist is saying here is whatever that idea of state sovereignty is that's embodied in the 11th Amendment was necessarily limited by the terms of the 14th Amendment. Just look at the very first words that we have quoted here under Section 1. No state shall. And then there's a big list of the things that the states cannot do. So, and then Congress has the power to enforce those prohibitions on the states. So Rehnquist says you read the amendment, you consider the historical context in which it was enacted, and it's clearly intended to diminish state sovereignty, but not only to diminish state sovereignty, to expand Congress's powers corresponding to that diminishment of state sovereignty. And therefore, so long as the legislation is quote-unquote appropriate legislation, in the language of Section 5, then Congress can subject states and or state officials to private suits as it sees fit. So that's the lesson of Fitzpatrick. Really, I think quite a simple concept here that if Congress has passed a valid Section 5 piece of legislation, then so long as the legislation is clear in the text of the legislation, it can subject a state to damages suits, or to any sort of suit, without regard to the 11th Amendment. All right. So what about Congress's powers that we're more familiar with, that we're already familiar with under Article 1, Section 8? Can Congress abrogate states' 11th Amendment immunities under its Article 1 powers, under its Commerce Clause powers, under its post office power, under its power to raise armies and navies, all of those powers in Article 1, Section 8. So here we have the Indian Gaming Regulatory Act. And this act is passed pursuant to a power that we haven't studied directly, but is related to the Interstate Commerce Clause that we've looked at, and this is known as the Indian Commerce Clause. Now, if you take a class on Indian law, the whole class will be devoted, almost the whole class will be devoted to studying Congress's powers under the Indian Commerce Clause. It's misleading somewhat to call it the Commerce Clause, although it gets this term because it's in the Commerce Clause. Remember, the Commerce Clause allows Congress to regulate commerce amongst the several states, so that's the one that we've looked at, with the Indian tribes and with foreign nations. But the Supreme Court has said that the Indian Commerce Clause essentially gives Congress full authority to regulate every aspect with respect to Indian tribes. So it's almost as though Congress has a free-for-all power to regulate Indian tribes here. And therefore, Chief Justice Rehnquist, by now 1996, when Seminole Tribe is written, he's Chief Justice. As he explains, just skipping ahead for a moment, over on page 454, right in the middle of that page, he says, if anything, the Indian Commerce Clause accomplishes a greater transfer of power from the states to the federal government than does the Interstate Commerce Clause. So again, just to emphasize, the Indian Commerce Clause really lets Congress do just about anything with respect to Indian tribes, completely alienating the states from being able to regulate Indian tribes. Okay, so the Indian Gaming Regulatory Act, this is passed pursuant to Congress's commerce power, Indian Commerce Clause power. So how does this come about? It has a very interesting backstory. I won't spend too long saying anything about it, or I won't spend too long saying much about it. But let me just give you the background. So what happened before the Indian Gaming Regulatory Act, or IGRA as it's sometimes called, before that was passed, because Congress's power over tribes is plenary, and because it's plenary, and it's general as well. Congress almost has a police powers type of regulation over Indian tribes. That means that the states are completely removed from having any regulatory authority over tribes. So Indian tribes had been able to set up casinos, other gaming institutions, whether it was slot machines or betting tables, however they wanted to, merely with the approval of the federal government, which with respect to tribes is usually the Secretary of the Interior. And the states had no say whatsoever. But some states started to complain about this because when an Indian tribe put up a new casino, this might be in a rural part of the state, if many tribes are located in rural parts of states. And especially in states that themselves did not allow gambling, this would be a huge draw to this reservation area that had previously been very little trafficked. And so states were complaining that this was creating bottlenecks on roads that weren't meant for high traffic. And therefore, the states were complaining to Congress. So Congress decided to listen to the states and pass some bill that gave the states a little more say in these matters. So the IGRA allows for tribal gaming if certain criteria are met. And one of the requirements before any tribe erected a new casino was that they had to enter into a compact with the state in which the tribal land was located. And you can see the book on page 451 gives a very long excerpt of various parts of the act. But the bottom line is, if a state refuses to negotiate in good faith with the tribe, then a federal court can do several things upon complaint by the Indian tribe. The federal court can order the state to enter into negotiations. If that fails, the federal court can order mediation between the tribe and state representatives. And if that fails, ultimately, the federal court will recommend something to the Secretary of the Interior, and the Secretary of the Interior can then just make a decision that the Indian tribe gets to establish a casino under whatever conditions he decides he wants to put on them. So what the court concludes is this constitutes an unequivocal intent to abrogate state sovereign immunity, because it's clear from the text of this statute that Congress contemplates states being sued by Indian tribes under these particular provisions. So then it's clear, just like with the Civil Rights Act of 1964, as amended in 72, that Congress intends states to be sued when they violate the terms of the federal statute. So far, this looks the same as the Fitzpatrick versus Bitzer case. So what's different? Right. What's different is the congressional power under which the statute is enacted and upon which Congress relies. So let me say a little more about the Indian Commerce Clause. So Congress has plenary authority over the tribes, and it does not have to grant the states any authority in tribal matters, right? And before IGRA, it didn't, with respect to gaming, to casinos and gaming establishments, right? But here, Congress is being generous. Congress was responding to state concerns, and though it didn't have to let states have any say over the matter, it decided it wanted to. So you might ask this question as we look at the holding of this case: shouldn't the greater power, the power to oust states altogether from these decisions, include the lesser power, the power to subject them to federal court jurisdiction here? And maybe that's not a case of the greater and the lesser, but you could ask the question nonetheless. And another question we could ask: if federalism is what's important, if that's the value behind the 11th Amendment, to preserve some state sovereignty against federal encroachment, doesn't this opinion, rather, the Seminole Tribe opinion, incentivize Congress to ignore the states in the future? Because the court is going to invalidate this attempted abrogation of sovereign immunity here, saying that the Article 1 powers can't be used to abrogate immunity. But Congress here is faced with Congress is put in an odd position after this, because it tried to bring the states into the matter, and one way it wanted to bring the states into the matter was saying, okay, you want to say in these matters, states, then we want you to negotiate in good faith with the tribes. And the states say, well, we don't want to do that, or we'll do it if we feel like it. And when they don't feel like it, and this Indian tribe brings a suit, the state claims immunity. And indeed, the court itself recognized this odd position, because at trial, or rather not at trial, at oral argument, when this case was in the Supreme Court, one of the justices' very first questions was, so here the tribe was the petitioner, so they argued first, but this question was asked of both sides. They said, aren't you arguing the wrong side? Or why are you contesting the opinion at all? Because it seems like each side should have been arguing the other. Because note, it seems like it's in the Indian tribe's interest to keep the states out of this altogether and just allow the Secretary of the Interior to grant them the permit. It seems like it's in the state's interest to keep this statute alive, because this was the state's only hope of having a voice in these matters. But both said at oral argument that the underlying principle of sovereignty, both for the state as well as for the tribe, were important to them. So that's the reason that this case came about. All right, so my previous question, shouldn't this case be controlled by Fitzpatrick? And over to page 455, the court explains to us that Fitzpatrick was based upon a rationale wholly inapplicable to the present case. So let's look at the middle of page 455. After the court says that, Fitzpatrick was based upon a rationale wholly inapplicable to the Interstate Commerce Clause, viz. That the 14th Amendment, adopted well after the adoption of the 11th Amendment and the ratification of the Constitution, operated to alter the pre-existing balance between the state and the federal powers achieved by Article 3 and the 11th Amendment. Okay. So Fitzpatrick here is justified by the fact that the 14th Amendment comes after the 11th Amendment, and therefore the last in time alters everything that pre-exists it. But here, the 11th Amendment came after the Indian Commerce Clause, and therefore it's the Indian Commerce Clause that's limited by the 11th Amendment, as opposed to the 11th Amendment being limited by the 14th Amendment. So if you picture these things on a timeline, according to the majority here, it goes Indian Commerce Clause, 11th Amendment, 14th Amendment, and the latter restricts or modifies the former. So what about this other precedent that's on the books? And there was a little note about this over on page 449, 450. This case called Pennsylvania versus Union Gas Company, which the court says right in the next paragraph, we feel bound to conclude that Union Gas was wrongly decided and that it should be and now is overruled. So Union Gas was a case where the court decided that Congress could abrogate states' sovereign immunity based on its Article 1, Section 8 powers. This was a 5-4 opinion, just as Seminole Tribe is a 5-4 opinion. This was a 5-4 opinion, but Justice White, who joined the majority, the 5-person majority, did not sign on to the opinion written by Justice Brennan. And therefore, as the court here, as Chief Justice Rehnquist says here in Seminole Tribe, there isn't really a majority opinion upon which to rely to understand what the court's rationale was in Pennsylvania versus Union Gas. So remember the opinion Hans, which described last class. This is the case from 1890 that says that the 11th Amendment, although it by its terms only prohibits suits by out-of-state citizens against a state, the court said that it's the spirit of the 11th Amendment should also prohibit a suit against a state by one of its own residents. And the court here, the Seminole tribe, well, the Pennsylvania versus Union Gas Court read Hans as recognizing a common law immunity principle, not a constitutional principle. So in Hans, there was no federal statute. Hans, the Louisiana citizen, was simply claiming a violation of the Constitution's Contracts Clause because Louisiana was not honoring the bonds that they issued. And the Pennsylvania versus Union Gas Court understands Hans as saying that this principle or this spirit of the 11th Amendment is really a common law spirit derived from the English common law, which is evidenced by that principle that king can do no wrong. Because it was a common law principle, the Union Gas Court held that Congress could alter it through ordinary legislation, just as Congress can alter any common law principle. Right? And then Rehnquist emphasizes the fact that there was no majority opinion. And then one important point I will mention, go over to page 454. When the court explains the role of stare decisis here, the court says that Union Gas is not entitled to stare decisis for a number of reasons. One being that there was no majority opinion, but two, Rehnquist says that Union Gas was clearly wrongly decided. Just a point about the hierarchy of stare decisis. You'll note that if you look at the second to last paragraph on page 454, the court talks about the principles of stare decisis. Nevertheless, we've always treated stare decisis as a principle of policy. When governing decisions are unworkable or badly reasoned, this court never felt constrained to follow precedent. Our willingness to reconsider our earlier decisions has been particularly true in constitutional cases, because in such cases, correction through legislative action is practically impossible. Students often miss this point. You learn about stare decisis your first year. But in terms of the hierarchy of stare decisis, so the Supreme Court has said that there are basically three types of decisions a court can issue. There's a decision interpreting a statute that the legislature has passed. There are decisions, there are common law decisions, and then there are decisions that interpret the Constitution. Which of those decisions, statutory interpretation decisions, constitutional interpretation decisions, or federal common law decisions, which type of decision is most deserving of stare decisis? In other words, which decision should be less likely to be overruled, or the least likely to be overruled? And the court has said surprisingly that, or maybe this is counterintuitive, that statutory interpretation decisions should be given the most stare decisis effect. Why is that? Because a statute can easily be changed by the legislature, in this case by Congress. So if the court gets a statute wrong, if let's say Congress thinks that the court has misinterpreted a statute, the legislature, Congress, can always go back and change that statute. And therefore the court has said we should stick to one statutory interpretation, because then that opinion can always be changed. And if we, the court, are changing a statutory interpretation, let's say we interpret things, a statute one way one year, and then another way the next, and then another way the next. If Congress is looking at the statute, Congress benefits from stability of interpretation. And then the type of case that should be subject to overruling most easily, the court tells us, are constitutional rulings. Constitutional rulings are the least subject to stare decisis. And why is that? Well, the court says it here, because in such cases, correction through legislative action is practically impossible. So the Supreme Court recognizes that really only the Supreme Court can overturn constitutional decisions, and therefore it should be most willing to reconsider those decisions, recognizing that the Supreme Court, is the only game in town when it comes to constitutional interpretation. Okay, and if, let's say, the court recognizes that it's not perfect, sometimes it might get cases wrong. If it gets a statutory interpretation case wrong, there's always someone else who can correct it. But if it gets a constitutional interpretation case wrong, the court recognizes that it's the only one that can correct that. All right, so the court says we're going to overrule Pennsylvania versus Union Gas Company. What's the rationale for the overruling? Well, the court says that, another reason to overrule Union Gas, as the court says at the very top of page 455, that Union Gas essentially eviscerated our decision in Hans. So Hans was correctly decided according to the Seminole Tribe Court, both in law and as a matter of history. So Hans says that, and we didn't read Hans, so don't worry if all of this isn't crystal clear, or it's not clear to you why all of this matters so much. I'll try to show you in a chart again. But Hans held that the 11th Amendment, although by its terms it only prohibits an out-of-stater from suing a state in federal court, that the spirit of the 11th Amendment, this background principle of sovereign immunity, also prevented an in-state person from suing. Now, the case that the 11th Amendment overruled, Chisholm versus Georgia, was a diversity case, right? A South Carolina citizen was suing the state of Georgia on a contract. The only reason they were in federal court was because of diversity of citizenship. The reason that Hans took Louisiana to federal court was clearly not diversity. It was a federal question. He was suing not based on a state law claim like a contract, but Hans was suing based on a constitutional principle. Now, one argument that many scholars have made since, but that was made by counsel in Hans at the time, was that the 11th Amendment actually, the reason that it talks about suits by out-of-staters is that the 11th Amendment was really only intended to prohibit diversity cases. It was only intended to limit jurisdiction in diversity cases, not in federal question cases. So what the Hans court said is the Hans court was perplexed. The Hans court said, we don't see why only an out-of-stater should be prohibited from bringing suit, but an in-stater should. And they were thinking just of Hans's constitutional claim. They said that doesn't make sense to us. And therefore we should prohibit Hans from bringing the suit because an out-of-stater couldn't bring a similar suit. But the court in Hans thought that the distinction between federal question and diversity didn't matter, that wasn't the point of the 11th Amendment. And so when the court here says that Hans was correct as decided, that's what they're referring to, that Hans was correct to view the 11th Amendment as prohibiting all types of jurisdiction, not just diversity jurisdiction. Then the second point here, that this spirit of the 11th Amendment, what is the nature of this spirit or this background principle of sovereign immunity? Is it a constitutional principle or is it a common law principle? If it's a common law principle, then like the common law, the legislature can always overrule it. If it's a constitutional principle, that can't be overturned. Right. And because Hans was correctly decided, the fact that Union Gas essentially eviscerated Hans added to the reasons why the court thought Union Gas should be overruled. Because Hans established a jurisdictional, i.e. a constitutional and not a common law principle, Congress cannot override the limits of Article 3, according to the court. All right. So that's the explanation for the majority's opinion in Seminole Tribe. Justice Stevens' dissent is not included here on page 456. He has a very lengthy dissent. Justice Souter also has a very lengthy dissent. We only have a small portion of it. If you're interested in this material, those two dissents are well worth reading. What does Justice Souter say in response to the majority's opinion? So he disagrees with that basic premise that motivated the overruling of Union Gas. So Justice Souter says Hans was wrongly decided. It wasn't rightly decided, the way the majority says. Why was Hans wrongly decided? So Justice Souter says it was wrong because that court failed to understand that the 11th Amendment was only intended to limit diversity jurisdiction. I think I explained some of this in the last time. The 11th Amendment, most historians agree that the 11th Amendment was designed to overturn Chisholm versus Georgia. But what about that case was objectionable? What was objectionable was the enforcement of state debt obligations, especially after the Revolutionary War, right? Which Chisholm versus Georgia was a Revolutionary War debt case. So it makes sense to understand the 11th Amendment as merely limiting that sort of diversity jurisdiction, because when you look at the framing debates, when you look at the ratification debates, you do see concerns that some framers make, that some ratifiers make, that Article 3 might be interpreted to do exactly what the Chisholm versus Georgia court said could happen, which is that a state could be brought into federal court and made to pay its debts, and the worry was that this might bankrupt states. So it seems pretty clear that that was the primary worry of those who eventually adopted the 11th Amendment. So Justice Souter says that Hans, which is 100 years removed from the 11th Amendment, gets history wrong, and it should not have applied any principle, the text of the 11th Amendment or the spirit of the 11th Amendment, to a federal question. Right? Because what Hans said is, it said that there's this anomaly. We don't see why someone. So the hypothetical that the Hans court was thinking is, so suppose that Hans wasn't a Louisiana citizen. Suppose a Texas citizen had purchased some bonds from Louisiana, and he was upset that Louisiana had repudiated those bonds and now wasn't going to pay them. The Supreme Court in Hans was thinking, why should that Texan be ousted from federal court when Hans, the in-state citizen, is permitted by the literal interpretation of the 11th Amendment's language? And the court said this is an anomaly. Both seem equally meritorious. Both have been cheated out of money by the state of Louisiana. Both should be in the same situation. Either should be able to be brought into federal court, or both can't come into federal court. And Justice Souter says this is an anomaly of the court's own making, because both would rest on the same constitutional ground, and therefore both should be able to come into court. So this problem that the Supreme Court thought existed in Hans doesn't really exist if you read the amendment properly. And another problem with being so concerned with Hans as the Seminole tribe majority is that Hans didn't ever address the abrogation issue, because there was no statute at issue there. Hans was suing directly for a violation of the Constitution, not for a statute that Congress passed pursuant to one of its constitutional powers. So therefore, Hans doesn't address the question whether the spirit of the 11th Amendment that it was so concerned about was a constitutionally based principle or a common law based principle. And Justice Souter says we can actually understand what was motivating the Hans court. And it was actually something similar to what was motivating the adopters of the 11th Amendment. So where did these bonds that Hans wanted Louisiana to pay him come from? Well, they came from the state of Louisiana's Civil War debts. So just as Georgia didn't want to have to pay its Revolutionary War debts, Louisiana was trying to raise money by issuing these bonds for its Civil War debts, and then it essentially retracted the legislation through which it issued these bonds. So both states were in a similar position, and what Justice Souter says in his very lengthy opinion is he goes through this and he says, even though Hans got the decision wrong, we can at least understand where they were coming from. They were coming from a similar place as those people that didn't want the state of Georgia to be sued back in 1793. They didn't want the state to have to answer for its debts based on a war, and that could potentially greatly deprive them of planning their budget in the future. So Justice Souter says Hans was wrong, but we understand where they're coming from. Therefore, his preferred method and the method of the other two members, the three-person dissent here, they wouldn't overrule Hans, but they would effectively neuter Hans. So Justice Souter says we should think of Hans like this, that yes, maybe we shouldn't read the 11th Amendment literally, as prohibiting only suits by out-of-state citizens. We can recognize this background principle of sovereign immunity that Hans talked about, but it should be considered a common law type of immunity. It should be considered to derive from the English common law that the king couldn't be sued in his own courts. As a common law principle, sovereign immunity should be subject to legislative revision. And Justice Souter says the doctrine should not be constitutionalized, lest we forget history. So if you look on page 457, the third paragraph from the bottom, he says, in ignoring the reasons for this pervasive understanding at the time of ratification, so again, he's saying the majority is the one that's misunderstanding history here, and in holding that a non-textual common law rule limits a clear grant of congressional power under Article 1, the court follows a course that brought it to grief before in our history and promises to do so again. What is he talking about? Well, he's talking about the period in history when the court was enforcing these states' rights limits, when the court was saying if we don't protect the states, then Congress will obliterate the distinction between what's national and what's local. All of that case law that was repudiated in 1937 when the court switched, the great switch in time, when the court switched from striking down Franklin Roosevelt's New Deal legislation to when it started upholding that legislation. And remember, the justification was sometimes the 10th Amendment, but it was these dualisms that the court had invented. And Justice Souter is saying that the majority here is doing the same thing. So what Souter would do is leave Hans as a background rule of common law immunity for all suits, diversity as well as federal question, recognizing that that's wrong, but he doesn't think it should be overruled necessarily. But if we leave it as a background rule of common law immunity, then Congress can alter it through any valid enactment. And it should be, hopefully you can see the parallel between what's going on here and what went on in the 10th Amendment cases that we studied a couple weeks ago. Remember, because both are dealing with both lines of cases are dealing with non-textual interpretations of the 10th Amendment and the 11th Amendment, and these non-textual interpretations claim to be motivated by the spirit of states' rights that the majority thinks is present in both of those amendments. So think of that back and forth, right? Wirtz said Congress, through its Article 1, Section 8 powers, could tell the state governments what to do. Like, you have to pay your state employees minimum wage. That was Wirtz. Then, less than a decade later, no other than Justice Rehnquist writes National League of Cities, says the 10th Amendment prohibits Congress from using its Article 1, Section 8 powers, its Commerce Clause power, to tell state governments what to do. Then, less than a decade later, the court overrules National League of Cities in Garcia. And then, less than a decade later, in the case of New York, followed closely up by Prince, the court doesn't overrule Garcia, but they develop this new carve-out for when Congress can't use its Article 1, Section 8 powers to regulate states. Here we see something similar. The Brennan opinion in the Pennsylvania versus Union Gas case, Congress can use its Article 1, Section 8 powers to subject states to suits. Then, less than a decade later, Justice Rehnquist, now Chief Justice Rehnquist, overrules that opinion, saying this principle of states' rights, state sovereignty, says no, Congress cannot use its Article 1, Section 8 powers to subject states to suits. And Is there anything else that we should have on that list? Maybe. A tiny note on page 461, a case called Central Virginia Community College versus Katz, 2006, so a decade after the court decides Seminole Tribe. And we have a very interesting opinion by Justice Stevens. You don't need to know any of the details, but the court holds that when Congress is passing legislation pursuant to its Article 1, Section 8 power to legislate on bankruptcies, that Congress can subject states to suits regardless of the 11th Amendment's sovereign immunity. 5-4 opinion, exact same court as the earlier court, but Justice O'Connor, in one of her last opinions before she retired, switched sides. So Justice O'Connor had been in the majority in Seminole Tribe, and she joins what had been the 4 dissenters in Seminole Tribe to make up the majority in this Virginia versus Katz case. And Justice Thomas writes a dissent saying this seems to be inconsistent with Seminole Tribe. He says if the court really wants to get rid of Seminole Tribe, they should just overrule it rather than trying to make a distinction. So that's the equally complicated lineage of 11th Amendment cases. This chart looks complicated, and perhaps it is, but I just wanted to point out to you the various methods that people have used to argue how the 11th Amendment should be interpreted. There's the literal interpretation, which says that only out-of-staters should be prohibited from suing states in federal court. Right? As you can see, the bottom there, there's no modern defenders of that on the court today. Go over to the right. This is an interpretation that was favored by Justice Brennan. This is an interpretation that has a lot of scholarly support. If you look at law review articles written in the late 70s, but especially in the mid 80s, you'll see a lot of scholars arguing for this interpretation that the 11th Amendment was really just intended to limit the diversity jurisdiction in cases when a state might be made a defendant in federal court. And as you can see there, the solid minority of the modern court accepts this approach. And then the middle is the one that really is at issue in Seminole Tribe, that the 11th Amendment is not the sole source of immunity. Instead, there's this background principle of sovereign immunity, or this spirit of the 11th Amendment. State immunity is broad. It covers everything, not just diversity, but it extends to federal question cases. This interpretation understands Chisholm versus Georgia to have been wrongly decided, and therefore the 11th Amendment is an attempt to correct the Supreme Court's misinterpretation in 1793, right, and restore that background principle of sovereign immunity. And Hans didn't express what type of principle this was because there was no federal statute at issue in Hans. But you can see here what really divides the majority from the dissent in Seminole Tribe is whether or not this background principle is a common law principle or a constitutional principle. The majority finds it to be a form of constitutional immunity. The compromise that Justice Souter's dissent represents is this view that it's a common law type of immunity that Congress can waive through ordinary legislation whenever it wants to. Just one last point to show how the dissent finds the majority's opinion, especially with respect to the constitutional nature of this immunity. The dissent finds this hard to accept as a matter of principle. So go over to page 459 and notice the language. So this is the big paragraph just before part 4 of the opinion, right in the middle. Where it says the paragraph that starts, the most damning evidence for the court's theory rests on the broad rationality of immunity unalterable by Congress. Then it's hard to see how a state's sovereign immunity may be waived any more than it may be abrogated by Congress. So Justice Souter is saying here, to the majority. So you say that this principle of sovereign immunity is constitutionally mandated, that it is a jurisdictional issue, that the Article 3 doesn't permit jurisdiction, federal court jurisdiction, when an individual tries to subject a state to suit in federal court. The federal court is without jurisdiction. But Justice Souter says, then how do you explain the fact that a state can waive its immunity if it wants to, or that Congress can waive or abrogate the state's immunity? Because in Marbury versus Madison, remember that famous 1803 opinion from Chief Justice Marshall, the holding of that was that Congress could not alter Article 3. Congress could not give the Supreme Court original jurisdiction where the Constitution didn't set out that jurisdiction. So Souter is saying it doesn't really make sense to call this in one breath jurisdictional, and then to say in another case, like Fitzpatrick, or any of the cases that talk about waiver, that this jurisdictional requirement can be waived. Think of other jurisdictional requirements that we've studied, like all of those justiciability doctrines. Remember, the justiciability doctrines were just another way of saying whether or not something was a case or a controversy within the meaning of Article 3. And it's very clear that a party cannot waive a jurisdictional requirement. Right? A party with no standing isn't going to be able to bring his case, even if the defendant says, I don't care that the plaintiff doesn't have standing, I really want the court to hear this case. The court would say, no, you can't waive a jurisdictional requirement. Or think of the Lujan case that we read, where Congress was not permitted to create standing, where standing otherwise, Congress was not permitted to waive the constitutional requirements of standing. Let me be clearer there. Remember, so just go back to the Lujan case. Why did the court say that Congress could not create standing in every person to bring a claim that the executive had violated the law? Is it something special about the 14th Amendment that allows Congress to waive standing, to waive the 11th Amendment immunity? It would seem by that logic then that if the 14th Amendment really altered everything that came before it, it would seem then that if Congress passed a piece of legislation under Section 5, under this theory of the majorities in Seminole Tribe, that then Congress should be able to say, a plaintiff doesn't have to have standing to bring a suit under the Civil Rights Act, because if we can waive a jurisdictional requirement based upon our 14th Amendment power, we should be able to waive another jurisdictional requirement under our 14th Amendment power. So anyway, that's just another one of Justice Souter's points to show that the majority opinion in Seminole Tribe doesn't really make sense. All right, so that's been I think that's been long enough. Again, I realize this is complicated material. The quiz questions that I will post, I will try to give you maybe a recorded explanation for these 3 days in particular, because I know that this material is more difficult, so that everyone can have access to the same explanation. But I'll do that after the day's quiz is over.